Hello and welcome to the Blue Turtle Management and Consulting web-based forum. You're watching episode 5. My name is Ian and today we're going to discuss the subject of the Client Architect Agreement. Today's episode will include the following: the top 5 reasons why you should implement a contract with all your clients, a brief look at where to get the latest Client Architect Agreement published by the institutions, the 4 most important issues to consider when reviewing an architectural agreement, and where to get a concise summary and explanation of typical contractual terms and meanings. Now, since starting Blue Turtle Management and Consulting, I've had the fortune to speak with many architects who run their own small practices. Unfortunately, however, many of these architects have suggested to me that although in theory a written signed agreement with your client is great, in reality it proves to be a waste of time, especially on the smaller projects. Now, when addressing architects that are not implementing contracts on their projects, I usually take this as an opportunity to ask them one simple question. How is working without a signed contract working for you? If you're being paid on time and in full, if you're happy with the way the project flows, and you're not experiencing any cash flow problems, then maybe whatever you're doing is working for you and you don't need to change. However, unfortunately, this is seldom the case. So let's start by looking at my top 5 reasons why you, as an architect, should implement and understand your agreement with your client. Firstly, typically all professional indemnity insurance policies require that the architect enters into a signed agreement with the client. If you don't do this, you may not be covered under your insurance policy. Secondly, many architects I speak to are disappointed with the way clients view their profession, and implementing a contractual arrangement between the parties is just one step that you can do to help provide a more professional and respectful service. Thirdly, it's been my experience that few architects, especially architects in large practices, few of them actually read the client architect contract. If you do read it and you can understand it, then you'll be a much more valuable member of the team, and this will come in very handy for your annual appraisal or if your firm starts to downsize. Fourthly, clients, especially developers, will always try and get the most value out of their architects. If you understand your contract, then you can avoid completing additional work or providing expense-related items for free. And finally, projects tend to be more profitable when you get paid on time and in full. If the project is more profitable, you stand more chance of earning more money, and if that's not a motivator, I don't know what is. So, where can you get a copy of the most up-to-date Client Architect Agreement? Well, if you're practicing architecture in Australia, then you'll need to know that both the AIA 2005 long-form and short-form agreements have now been replaced with a new document called the 2009 Client Architect Agreement. The 2009 Client Architect Agreement costs $35 Australian for non-members and $15 Australian for members, plus postage and packaging, and it's available through Knowledge Services. Now, to purchase a copy, go to the Australian Institute of Architects website, www.architecture.com.au, then click on the Products and Services link, and then the Contracts link. You will then be able to download a mail order form and purchase a copy. However, if you're practicing architecture in the UK, or would like to see the RIBA agreement, then you'll want to get a copy of RIBA Standard Agreement 2010, which recently superseded the RIBA Standard Form of Agreement SFA 99. Now, to download a copy, simply go to www.ribabookshop.com. The latest agreement costs 32 Great British pounds to purchase, which is approximately 60 Australian dollars, and it can be downloaded from the site. Now, before entering into a contract with a client, you'll want to engage the services of good legal counsel. This is even more important if you're thinking of being appointed under an amended version of a standard form of agreement, or if you're looking at working in a new territory or region. It's always quite surprising and somewhat disturbing just how different construction laws can be for different places, even within the same country. For example, about 10 years ago, I was working as a project manager for a builder in the United States, and during that time I was involved in writing and managing subcontractor agreements. Now, paid when paid and paid if paid contractual clauses were fairly common tools used by builders at that time, and possibly still are. For those of you not familiar with this clause, a paid when paid clause basically states that if the builder is not paid by the owner, the builder has no obligation to pay its subcontractors. So as a builder, it's quite a desirable clause to have. So here's the catch. In Texas, pay when paid clauses are typically enforceable by law. However, in California, they are not. While working in Texas, I helped manage a project that experienced client payment issues, and unfortunately I had the very undesirable task of settling the subcontractor accounts. Now, if this project had been located in California, the financial outcome would have probably been very different for all parties, especially us as the builder. So the lesson here is do not wait until the project is awarded make sure you engage the services of legal professional advice before submitting a proposal or signing any agreements, as laws will vary significantly. So let's take a look at a contract and get familiar with exactly what you should be looking for when reviewing an agreement that's either not a standard or it's a client drafted agreement or something of that nature. Now, as a minimum, when reviewing contractual terms and conditions, you should always be asking yourself the following question. Are these terms fair, reasonable, insurable, and legal with respect to the size of the project, the location, and level or type of service to be provided by the architect? So let's take a look at exactly what we mean by fair, reasonable, insurable, and legal. Now, by fair, I mean that the contract is not unduly weighted towards either side, but provides terms that are both balanced and mutually acceptable. One way of saying this is what's good for the goose should also be good for the gander. And by reasonable, I mean that the contractual terms take into consideration the type of project and level of service to be provided by the architect. Insurable simply means that the terms are sufficiently covered by the architect's professional indemnity insurance. If it's not covered by that insurance policy, then there should be another policy that's easily attainable by the architect. And by legal, I simply mean that the contractual clauses take into consideration all relevant laws applicable to the region in which the work is to be completed. So let's take a look at some typical clauses and see how we can address them. Let's start by looking at payment clauses. That's perhaps one of the most important. Now, when addressing payment clauses, it's both fair and reasonable that the architect should be entitled to receive regular payment for services rendered. Now, point here is the regular part. When deciding on what the regular part should be, you may want to look for common payment precedents. If both the architect and the client have obligations to pay staffing and overhead costs on a monthly basis, and typical service fees are also paid on a monthly basis, then it seems both fair and reasonable that the architect should also receive payment on a monthly basis. So avoid agreeing to being paid at the end of a long work stage, as this could be months later, which would ultimately strain your cash flow and jeopardize your financial position. Now, obviously, if you're working on a very small project that only lasts for, let's say, a month, it may be more appropriate to ask for 50% of the fee up front and 50% at the end of the month. So once again, what may be considered fair and reasonable does depend on the size and type of project. Similarly, things like termination and suspension clauses should apply to both parties, not just the architect. If the client has the right to suspend or terminate the agreement, then it's only fair that the architect should also have the right to suspend or terminate its involvement in the project if it's so deemed necessary. Plus, it's both fair and reasonable that the notice periods for things like termination and suspension clauses be the same for both parties. If suspension is upon 7 days' notice for the architect, then it's fair that it's the same time frame for the client. Now, copyright clauses are also another big item that you'll want to address. When discussing copyright clauses, because an architect's ability to build a brand and develop a practice is strongly influenced by retaining the copyright, it's unreasonable and unfair for the client to demand ownership of this. However, you will come across projects where the clients do request the copyright. Now, if the client is paying for the work, then it's fair that the client be able to use the work for which it was prepared and provided. So you should therefore provide a license agreement giving the client the right to use the design documents for the intended purpose. Make sure, however, that any licenses that you provide are non-exclusive licenses and subject to payment of fees due. When discussing insurance clauses, the level of insurance to be provided should reflect a fair and reasonable balance relative to the architect's fee and possible exposure. If the architect is performing work on a small project for a relatively small fee, then it seems fair that the architect's liability should also be smaller or less than that of a larger project with more work and a larger fee. Now, one way you can limit your liability is by implementing what is known as a cap on liability clause. Similarly, it's unreasonable to enforce clauses which either extend the architect's liability beyond the architectural scope or hold the architect responsible for issues beyond his or her control. Indemnity clauses often seek to do both of these things and therefore need to be removed or restricted. Retention and set-off clauses are also examples of unreasonableness in an architectural contract. Any clause that undermines the architect's entitlement to appropriate remuneration for services should be removed or restricted. There are, however, other issues that may not be so obvious. For example, many of the contracts I worked on in the Middle East required the architect to provide what is known as an on-demand performance bond. Now, bonds of any type cost money to provide, they impact your borrowing capacity, and can prove to be difficult to release at the end of the project. So if your firm has a strong history of performance and relevant or similar experience and is qualified to complete the work, then requiring a bond could be considered by some as unnecessary and therefore unreasonable. client-written contracts will often seek to transfer risk and liabilities that are uninsurable. For example, I've seen many contracts that include clauses involving predetermined penalties. One such example is a liquidated damages clause, which would allow the client to charge the architect a predetermined amount of money as compensation for a delay in service. Typically, the architect's professional indemnity insurance policy does not cover the architect for predetermined penalties, like liquidated damages. However, in the event of a breach, the PII policy will seek to cover the cost of the actual damage suffered by the client. So not only are the predetermined penalties uninsurable in most situations, but they are also unnecessary given that the client should already be covered under the architect's PII policy. Now, unfortunately, there will also be times when a client drafted agreement may include clauses that are in conflict with a law or statutory right. For example, in Australia, there exists a Securities of Payment Act, which loosely translated means that any person or company who performs work or supplies goods under a construction contract is entitled to receive and be able to recover progress payments for said work or goods. Any attempt by a client to modify or restrict this operation goes against the intended nature and purpose of the Securities of Payment Act, and therefore should be addressed and removed from the contract. Once again, when reviewing contractual clauses, you need to keep asking yourself the same question. Are these terms fair, reasonable, insurable, and legal with respect to the size of the project, the location, and the level or type of service to be provided by the architect? Now, during today's episode, we've covered many contractual issues in a very short period of time. If you're not working with architectural agreements on a regular basis, then you may not be familiar with all the terms that I've used today. If you would like an easy-to-use reference guide that lists and explains the most commonly used clauses in plain, simple English, then I'd like to recommend purchasing a copy of the Architect's Guide to Fees and Contracts. Chapter 9 of this book includes a long list of typical architectural contractual terms, definitions, and also a list of considerations. Now, obviously, understanding and deciding which terms in a client-drafted agreement are unfair, unreasonable, uninsurable, or legally questionable is just half the battle. The next step is to take action and address the clauses with your client. Now, it's important to understand that you as an architect have the opportunity to influence the terms in your agreement. So once you have recognized which clauses are unacceptable, make sure you take action. It's also good to remind yourself that if you want to increase the quality of architecture and the industry as a whole, then it's really important that you do your part and challenge or negotiate the unfair and unreasonable contractual conditions. Now, the subject of negotiating architectural fees and contracts is very wide-ranging, so we have dedicated a whole episode to the subject later in the series. In conclusion, implementing client-architect agreements on all your projects is a requirement of most professional indemnity policies. If you are unhappy with the way you're treated by your clients, then it's up to you to change it, and implementing and managing your project via an agreement is one step towards achieving this. Now, when presented with a client-drafted agreement, it's very important to challenge all unfair, unreasonable, uninsurable, and illegal clauses, and we'll be discussing more later in the series about how you can do that. Also, when reviewing clauses, make sure you consider the type of project, the location, and level of service to be provided. Always engage the services of professional legal counsel, especially when working with amended versions of standard agreements or when working in new geographic locations. For a list of common contractual terms, definitions, and considerations, go to Chapter 9 of the Architect's Guide to Fees and Contracts. You can purchase a copy at www.architectsguidetofeesandcontracts.com. Thank you very much for watching episode 5. Bye for now.